Picture this. You're sitting in your attorney's office, you're getting divorced, and you have a disability. You ask your attorney one question. What happens to my Social Security? What happens to my Medicare? What happens to the apartment I rent with the housing voucher in my name? Your attorney pauses, says, I'll have to look into that. So you call your caseworker at Social Security. You ask the same questions, and your caseworker says, that's a legal question. You'll need to ask your attorney. You are stuck between two systems, family law on one side, disability law on the other. Neither one talks to the other. And you're the person caught in the middle, with everything on the line. Today we fix that. We're going through exactly what happens to your benefits, your assets, and your rights when you go through a divorce, and what you need to do, starting today, to protect yourself.
Let's start with Social Security Disability Insurance, SSDI. The benefit you earned by working and paying into the system before you became disabled. Here is the most important thing I can tell you in this entire episode. If you receive SSDI based on your own work record, divorce does not affect your benefit. Your monthly amount stays exactly the same. Your ex-spouse cannot take a share of it. A judge cannot order it split. It is not marital property. Now that sounds simple, but there's a wrinkle, and you need to know about it. The joint account trap. If you have been depositing your SSDI checks into a joint bank account with your spouse, and you live in a community property state, those deposited funds can lose their protected status. Once they sit in a joint account, they can look like marital money. And in community property states, marital money gets split 50-50. The practical fix is simple. Open a separate account in your name only. Have your SSDI direct deposited there. Pay your share of household expenses by transferring money out. Do not let your disability benefits sit in a joint pool. That one step protects the character of those funds. When SSDI can be garnished. SSDI is generally protected from creditors, but there are exceptions. If you fall behind on alimony or child support, SSDI can be garnished to pay those arrears. The federal protection does not apply to family support obligations, and courts do count SSDI as income when they calculate alimony. So if you receive $1,800 a month in SSDI, the court will treat that as $1,800 of monthly income when it figures out whether you owe support or whether you should receive it. Divorced spouse benefits, a hidden right. Here is something many people don't know. You may be entitled to benefits based on your ex-spouse's work record even after you divorce. If you were married at least 10 years and your ex-spouse qualifies for SSDI or retirement benefits, and you are currently unmarried, and you are at least 62 years old, you can claim up to 50% of your ex-spouse's benefit amount. And here's the part people find hard to believe. Claiming this does not reduce your ex's payment. It does not take anything from them. Social Security pays it out of the system. There's also a divorced survivor benefit. If your ex-spouse dies and you were married at least 10 years, you may receive up to 100% of their benefit. You can claim it at age 50 if you are disabled, or at age 60 otherwise. SSI is a completely different animal. Now, if you receive supplemental security income, SSI, almost everything I just said works differently.
At RH Positivo TDF, 7 minutes ago. 10 suscriptores. It's not about you in particular. You're getting the brunt of 500 years of colonization. I've been watching your videos and I really enjoy the content. As an online creator myself, I have also been target of horrible comments, and not just online comments. In my particular case, I am an Argentinian woman who happens to also be a Canadian, who has lived over 20 years in Canada. Now I am back. I am cycling alone around the country. Imagine a local woman, alone, cycling carefree like it's North America on the highways. It's a shit show. From the online comments to in-my-face machismo, to having to go to the police and finding a system that is completely corrupt. I keep doing what I do. I don't think you will persuade any unreasonable person,
no matter how accurate the facts in this video are. An unreasonable person is unreasonable, period. There's a world issue now about blaming foreigners for everything, divide and conquer propaganda. A few years ago, the poor Venezuelans were the target of all the problems in many South American countries. Now it's the Americans. Now let's talk about health insurance. For most people with disabilities, this is the part that keeps them up at night. Losing coverage means losing access to medications, specialists, therapies. It can be life or death. Medicare on your own record. If you have Medicare because you qualified for SSDI for at least 24 months, that coverage is in your name. It is based on your own work record. Divorce does not touch it. Same plan, same premium, same coverage the day after the divorce as the day before. Medicare through a spouse. But some people get Medicare as a dependent on a spouse's record or through an employer plan tied to a spouse's job. If that's you, divorce can end that coverage.
COBRA is not free. You will pay the full premium, usually plus a small administrative fee, but it lets you stay on the same plan with the same doctors while you sort out a long-term replacement. Medicaid often goes up after divorce. Medicaid is income-based, and it counts your household. When you were married, the state counted both incomes. After divorce, the state only counts your income. For many people, that means qualifying for more Medicaid services after divorce than before, including in states where you may not have qualified at all while married. If you were not on Medicaid during the marriage, apply right after the divorce is final. Your household size and your income are different now. The math may work in your favor. Medicaid divorce, the hard conversation. I want to be honest about something else. There is a strategy that some couples use called a Medicaid divorce. It usually comes up when one spouse needs nursing home care, and the family is trying to protect the healthy spouse from being wiped out by long-term care costs. It is legal. It exists. It is also complicated, emotionally and legally, and it absolutely requires an elder law attorney who specializes in Medicaid planning. For 2026, the Community Spouse Resource Allowance, the amount the at-home spouse can keep, goes up to $162,660 in countable assets. There are also rules about income, the home, and a 5-year look-back on transfers. Do not try this without a specialist. COBRA is not free. You will pay the full premium, usually plus a small administrative fee, but it lets you stay on the same plan with the same doctors while you sort out a long-term replacement. Medicaid often goes up after divorce. Medicaid is income-based, and it counts your household. When you were married, the state counted both incomes. After divorce, the state only counts your income. For many people, that means qualifying for more Medicaid services after divorce than before, including in states where you may not have qualified at all while married. If you were not on Medicaid during the marriage, apply right after the divorce is final. Your household size and your income are different now. The math may work in your favor. Medicaid divorce, the hard conversation. I want to be honest about something else. There is a strategy that some couples use called a Medicaid divorce. It usually comes up when one spouse needs nursing home care and the family is trying to protect the healthy spouse from being wiped out by long-term care costs. When the paying spouse becomes disabled. Now flip the scenario. You are the one paying alimony or child support, and you become disabled after the divorce. Your income drops. You cannot afford the payment. You can petition the court to modify the order. The legal standard is a substantial change in circumstances. Becoming disabled qualifies. The court will look at the nature of the disability, the severity, how long it is expected to last, and how it changed your earning capacity. One warning: do not just stop paying. Arrears will pile up. You can be held in contempt. File the petition first. Pay what you can while it's pending. Get the order modified in writing by a judge. How different benefits are treated. Let me put this in plain terms. SSDI counts as income for calculating alimony and child support. SSI does not count as income for those calculations.
SSDI can be garnished if you fall behind on alimony or child support. SSI cannot be garnished for either, period. SSDI payments are generally not marital property and are not divided in divorce. The same goes for VA disability benefits in most states. They are protected from division by federal law. But VA benefits like SSDI can be counted as income when the court calculates how much support you owe or receive. Asset division and the commingling problem. I want to circle back to the commingling issue because it matters here too. Once disability benefits sit in a joint account, they can lose their protected character. Once you use SSDI to pay the mortgage on a house titled in both names, the line gets blurry. Keep disability money in a separate account. Pay shared expenses by transferring out. Keep records. If you are already deep in a marriage where everything is mixed together, a good attorney can sometimes trace funds back to their source. It is harder, but it can be done. Child custody is about the child. The legal standard for custody is the best interests of the child. Disability is not on the list of disqualifiers. A disability on its own is not grounds to reduce or remove your custody, but the court will look at your ability to care for the child day to day. That is reasonable. What helps you is showing the plan. Who helps when you need rest? What adaptive equipment you use? Where the medical appointments are? Whether the school is accessible? Whether you have a support network, family, aides, community. Show the court a plan that works. Most judges respond to that.
Let's go deeper here because this is where I see the most damage done. Parents with disabilities lose custody or get pushed into reduced visitation because of bias the system does not always recognize as bias. Here is the law. Disability cannot legally be the sole reason for denying custody. The Americans with Disabilities Act applies in family court. The Department of Justice and Health and Human Services have both said so in joint guidance. Family courts are public entities, and they cannot discriminate against parents on the basis of disability alone. Enforcement is uneven. I will not pretend otherwise. Some judges get it, some don't. But the law is on your side, and you have grounds to push back when you see a decision driven by stereotypes rather than evidence. What helps in court? A documented support system. Family members, friends, paid aides, community programs, anyone who is involved in your child's life. Names, hours, roles. A parenting plan that accounts for your disability. Not one that hides it. One that says, here's what I do, here's how I do it, here's the backup when I need it. Expert testimony when you can get it. An occupational therapist who can speak to your daily function. A disability specialist who can speak to capability. A pediatrician who has seen you parent. What hurts in court? Untreated mental health conditions used as evidence. If you have a psychiatric disability, get into treatment, document the treatment, and stay in it. The fact of a diagnosis is not the problem. A pattern of unmanaged crisis can be. Inconsistent documentation. If your child missed appointments, missed school, missed medication, the other side will use that. Keep records, calendars, pharmacy logs, texts with the other parent. Termination of parental rights. Termination is the most serious outcome a family court can order. The standard is clear and convincing evidence of harm or risk of harm to the child. Disability on its own does not meet that standard. Anyone telling you otherwise is wrong on the law. A quick international note. The United Kingdom, Canada, Australia, and most of Europe have similar frameworks. They recognize disability discrimination in custody cases as a problem. Enforcement varies by country and by region within each country. If you're watching from outside the US, the basics here still apply. Disability is not, by itself, grounds to lose your child. But find a local family law attorney who knows your jurisdiction. Let's land this with a clear list. 7 steps. Write these down. Step 1. Find the right attorney. You need a lawyer who knows both family law and disability law. They are rare. You may need a family law attorney plus a separate disability or special needs attorney working together as co-counsel. That is normal in these cases.
Ask up front whether the lawyer has handled cases involving SSDI, SSI, Medicaid, or special needs trusts. If the answer is no, keep looking. Step 2. Separate your accounts today. If you are even thinking about a divorce, open an account in your name only. Move your disability benefits there. Do this before you file. It is not hiding money. It is preserving the protected character of federal benefits. Step 3. Demand a special needs trust. If the settlement includes anything beyond a small amount of cash, a house, retirement money, a lump sum, insist that it flow into a properly drafted special needs trust. Get it in the divorce decree. Get it court-ordered if necessary. Do not let assets land in your name and disqualify you from benefits you spent years securing. Step 4. Document your disability expenses. Start a file now. Medications, copays, adaptive equipment, home modifications, transportation, caregiver costs. The court will use this when it sets alimony and divides assets. The clearer your record, the better the outcome. Step 5. Run the SSI math. If you are on SSI, every dollar of alimony above the small exclusion reduces your SSI by $1. Sometimes it makes sense to negotiate for a lump sum instead, paid into a trust. Sometimes for property instead of cash. Run the numbers with your attorney before you sign anything. Step 6. Call legal aid. Every state has a legal aid office. Many of them have family law attorneys and disability specialists under the same roof. If you qualify by income, and many disabled people do, the representation is free. Call before you assume you cannot afford a lawyer. You may be able to. Step 7. A note for Americans abroad. If you're an American with a disability living overseas and you're going through a divorce, your SSDI generally continues, no matter where you live. Social Security pays into most countries. There are a few exceptions, but the general rule is your SSDI follows you.
Medicare, on the other hand, does not cover care outside the United States. With very narrow exceptions, Medicaid is U.S. only. Plan for private international health coverage or coverage through the country you live in. Build that into the settlement if you can. Divorce is hard for anyone. When you have a disability, there are layers. Most attorneys and most caseworkers have never navigated together. Two systems, two vocabularies, and you, in the middle of it, trying to hold your life together. What we covered today won't replace an attorney, but it gives you the vocabulary. It gives you the questions to ask before you walk into that room. It gives you the steps to take this week, before you sign anything, before you move anything, before you agree to anything. Protect your benefits, protect your accounts, protect your kids, protect yourself. I'm Drew. This is disability.co. See you next week.